Hello, everyone. Welcome to another series of the IMPRINT Explained. And today, in the Indian Constitution and Polity News section, we are looking at the new judgment by the Supreme Court, that is, no 100% quota. And this is for the tribal teachers in Andhra Pradesh and obviously Telangana. And further in this judgment, they did talk about the fact that there has to be a revision in SC/ST list. What is the reason for that? We'll go into that in the video later. We'll also discuss the fifth schedule and Article 371D of the Constitution in this video, right? So let's start. Now, what does the Supreme Court say? So it says no rhyme or reason for 100% reservation. So that's the headline for this, article in the print and in the Indian Express and in the Hindu, if you can read. So the Supreme Court obviously has quashed 2000 order of the erstwhile nation, state of Andhra Pradesh. It provided 100% reservation to scheduled tribe candidates for the post of teachers in schools in the scheduled areas. And who are the five people? Arun Mishra, Indira Banerjee, Justice Arun, M.R. Shah, Aniruddha Bose. They ruled that the governor did not have the power to provide 100% reservation. Now, why did they say so? So what happened was the governor of the undivided Andhra Pradesh had cited Schedule 5 of the Constitution, which provides for administration of scheduled areas in states other than Assam, Meghalaya, Tripura, Mizoram to pass the government order, right? And what the Supreme Court says, that the state action defies logic and that merit cannot be denied inter toto by providing reservation, and that reservation in this case violated Article 14, that is equality before law, Article 15, 1, that is discrimination against citizens, Article 16, that is equal opportunity of the Constitution. And that is what it is saying. Now, what is Schedule 5? So let's try to look at that, why technically they disagree to this. So in Schedule 5, there's Part 5, right, 5, 1, which has been quoted by the Andhra Pradesh government, that why they directed. So it says it says governor may by notification, public notification, direct that any particular act of parliament or of legislature of the state shall apply to a scheduled area, or any part thereof the state shall apply to a scheduled area of that part. Okay, and this obviously the governor can make regulations for the peace and good government of any part of the area in any state, right? And prohibit, restrict transfer of land among members of the scheduled tribes, regulate the allotment of land to the members of the scheduled tribe in area, regulate the businesses obviously which are done by money lenders who lend money to members of the scheduled tribe. So they can actually look into these things. Okay. Now, what scheduled tribe, on the other hand, does not allow the governor to make laws. And that is what the Supreme Court is saying, that Schedule 5 does not allow the governor to make new laws. So paragraph 5 of the Schedule 5 empowers a governor to issue a notification directing that central or state law may or may not apply to a scheduled area, right? And obviously shall apply with modification, exemptions, and so on. But it cannot say that, okay, a new law can be made. So the court therefore held that the creation of the 100% reservation through government order was akin to making a new law, and Schedule 5 can only allow to apply or not to apply a law, right, into a scheduled area with modification. So therefore, this was taken away. Now, if you think about it, the governor of Andhra Pradesh has been repeatedly doing this. Okay, so in November '86, the then governor of Andhra Pradesh issued an order under the same schedule of the Constitution directing that the post of teachers in educational institutions in tribal area be reserved for scheduled tribes only. This was quashed by the Administrative Tribunal in '89. A challenge to the tribunal order was basically made, and this was withdrawn later by the government. Then in 2000, the governor issued another, this was the present one, right? Out of this, 33% was supposed to be reserved for women. The government said the order was to promote educational development of tribal and to solve the phenomenal absenteeism of teachers in the schools situated in the scheduled areas. And we'll talk about this a little later, and in a view to protect the interest of the tribals. This order was set aside by the Administrative Tribunal, but was upheld by the Andhra Pradesh High Court. The Supreme Court actually was hearing appeals against this order. Okay, so the 5-judge bench basically is saying that, despite the fact the earlier order had been set aside, you keep on doing this. And the state government may again, by way of misadventure, resort to similar exercises. And so the court also imposed 5 lakh penalty on the government, right, for this. Okay. what else happened, right? So this is the article in the Hindu, right? So pretty much the same thing they've talked about. Okay, something which they have also mentioned, which was not mentioned in the other article, was the fact that the president under 371D has issued order that a resident of a state or zone cannot apply to another zone for appointment. So if there's 100% quota, right, it deprived residents of the scheduled areas, right, of any opportunity to apply for teaching posts. So I cannot apply for any teaching post in my area because that's a scheduled area, because everything is reserved for tribals. If I'm a general category living in a tribal area, let's say, or somebody from a different category, so I cannot apply, right? And that under 371D. And this is Article 371D, a special provision with respect to the state of Andhra, right, and Telangana. And the idea is to have equitable opportunities and facilities for people belonging to different parts of the state in matters of public employment, in matters of education, and other provisions, right? So basically, this is the idea. What other problem came? So, if you think about it, this 100% reservation is totally wrong if you think about even B.R. Ambedkar. So Ambedkar observed during his constitutional assembly debates also that the reservation has to be a set of minority seats, right? And obviously, this is one of the points often argued in favor of the 50% cap imposed by the court in various judgments, right? Albeit for announced, there's certain cases in Tamil Nadu in which special circumstances exist, right? So the idea is this is fine. Maybe that the 100% reservation for STs, right, teachers is not right in scheduled tribe areas because that kind of isolates them. But on the other hand, the problem it creates is the fact that absenteeism is not going to stop. How would you guarantee? Should there be a bond or undertaking taken if a general category teacher is getting posted there in these areas that he will maintain a certain level of attendance? Should his terms of service be stronger than others? Okay, that's something like that can be actually be thought of. In this background, obviously, what has happened is something very, very strange. The courts tended to order a obiter dicta. What they did was they said that there has to be a revision in the list of SCs, STs. Right, while the power obviously to amend this is by the president, right, it is uncharitable to say that the advanced and affluent sections among the SCs, STs are cornering on benefits and do not permit any trickle down, because we are far, far away. If you look at the amount of posts that are there of SCs, STs and number of applications, you'll find that's not true. So I think with that, thank you so much for listening. Do like and subscribe. Do give our views. What could have been done? What can be a better solution to this? Right? Whether some other methodology can be done to prevent teacher absenteeism. And teacher absenteeism is rampant in rural areas, in Punjab, in Haryana, any place in India. And that is why government schools are so poor in India, and people are working towards private education or going towards it now. Thank you so much.